everybody, and welcome to the National Constitution Center's online class. I am Jenna Karras. I'm the Director of Learning and Engagement. I am substitute moderating for Curry Sautner today, but I am here with Tom Donnelly, who is our Chief Content Officer, and he's going to lead us through this Fourth Amendment discussion. Hi, Tom.
Hi, Jenna.
So today we are looking at the Fourth Amendment, and I started class, as people were coming in with this hypothetical question. The question is, can the government track you 24 hours a day, 7 days a week for an entire month using your cell phone data and location information? So think about that. Think about how you would interpret the Constitution based on this question, and we're going to get to it at the very end because this is a real case. It's Carpenter v. U.S. And to kind of take us on that journey, Tom is going to dive into this and some other big questions today. Why do we have a Fourth Amendment? What were the framers thinking? What led them to include it? What did it mean to them? And then how has that changed as our country has grown and new technologies have come into play? But Tom, as we always do, let's start with the actual words of the Fourth Amendment.
Absolutely, Jenna. And I mean, this is all what we're going to try to model in this class is how you go about just breaking down a constitutional question using our hypothetical as the example. So we're going to go with the Constitution's text. We'll say a bit about the Constitution's history, and then we'll really look into what the Supreme Court has said about the Fourth Amendment over time. But as Jenna said, we always like to begin with the Constitution's text. Here's the inspiring language. I'll read it aloud. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So if we really break down that text, we can see a few key parts that give us some answers about what the Fourth Amendment's protecting and when. And so first, it tells us which things are being protected by the Fourth Amendment. That's the people's persons, houses, papers, and effects. What are effects? Well, it's really our stuff. It's so a lot of the things that we own. It's a pretty broad word. What is the Fourth Amendment protecting against? Well, it's protecting against unreasonable searches and seizures by the government. That's the core protection. That's the core purpose of the Fourth Amendment. Who's the government here? Well, it's usually police officers. And so this is the amendment. This is a part of the Constitution that most governs our interactions with police officers over time. And then finally, the last part of the text, we also have the warrant requirement. And so with that warrant requirement, there are some interesting features of it. One is that what you see is that it on the one hand, what's there to do is to, in most cases, make sure that police officers go and clear a search with a judge before they carry it out. And so generally speaking, police officers have to go and get a warrant, but there are limits on what kind of warrants they can get. And we'll get into this with the story of James Otis at the founding in a moment. But what we see from the text of the warrant requirement is that you really have to be describing the person or the place that you want to search. You really need a specific reason to be searching a person, a place, particular things. And that has to be set down in the warrant. It can't just be a general warrant, a general blank check to police officers to search basically anything that they think matters. There has to be some specificity there. And also it has to be supported by what's known as probable cause.
So what is probable cause then, Tom?
Yeah, so I mean, it's a certain level of suspicion of criminal activity. It attaches to a particular person, place, or item. It's something less, it's certainly less than beyond a reasonable doubt. It's less than more probable than not. But in the end, it's something that requires a certain level of suspicion that's attaching to a specific person, place, or item.
Okay, so I mean, that's the kind of big question that we ask when we talk about these Fourth Amendment, just in general. Like you said, the government in this case is generally the police, and can they do that? So all of these kind of scenarios: can the police officers stop me on my street? Can they search my car, my desk, my nightstand? People were asking in the chat about computers. Does computers count as my stuff? Can they look at who I've called, where I've been, all of those kinds of things? Those are the kind of questions that we get when we're talking about Fourth Amendment. And so you've kind of broken it down for us where it's like, well, it's a very if they've have the probable cause or if they've gotten the warrant, these scenarios come into place. But the bottom line is this big idea here, which is what?
is that before the government can search your home or seize your property, it needs a good reason. I mean, really, I'm not going to read all of the text there. That's the big point, is that we think that searches and seizures of our persons, houses, papers, and effects, they're important things. And as a result, if the government wants to search them, it needs a good reason.
We are getting into a lot of fine details in the chat, so we're going to get to all of this. But before we get to the more modern cases and the technology and the computer, let's go back and figure out where we were coming from when we wrote the Constitution and this amendment into the Constitution. So tell us about James Otis, writs of assistance, and kind of what was the framers' point of view coming into including this in the Constitution.
Absolutely. So, I mean, let's go back to 1761. So this is 15 years before the Declaration of Independence. We're in colonial Boston, and the British Empire needs money. And so, the British Empire, it's carrying out wars, it needs money, and it's beginning to look to the American colonies to try to get that money through taxation, through enforcing laws that are already on the books. And so for many, many years before this, there have been laws on the books for the American colonies against smuggling. So that when you bring goods into the colonies, the British officials have to be able to collect a tax, the custom duties on them. But frankly, over time, the British Empire didn't really enforce these laws, and the American colonists very rarely followed them. And so we had pervasive smuggling in the American colonies, but now there's a new moment where the British Empire needs more money. And so it says, we're going to enforce these laws that are on the books to try to extract more money from the colonies, to make them pay the taxes that are owed. Why? Well, in part, one is because we have the laws on the books, and two is that the American colonists are relatively wealthy. There's a lot of money there, and they benefit from the security that we provide. And so we see the British Empire beginning to enforce these anti-smuggling laws. One key way in which they do it is that King George III begins using royal officials in the colonies to go after these smugglers and use what are called writs of assistance. These writs of assistance gave royal officials pretty much free rein to break into the homes of colonists to search for evidence anytime, anywhere, for any reason. So we can already see it's the very opposite of what we found in the Fourth Amendment's text, where we don't allow for these sorts of general warrants under the Fourth Amendment. Instead, we require the government to be able to say there's a specific reason that they're looking at a particular person, and also to be able to specify the place they're searching and the thing that they're looking for. So we see the absolute opposite of this in the context of the writs of assistance, and the American colonists fight back. Part of the reason is that it's many of the most prominent colonists in Boston that are the smugglers. And so they're the ones that are getting punished by the British Empire. And so James Otis, a prominent Boston lawyer, steps in and he represents these smugglers before the Massachusetts Superior Court. And he makes a really radical argument. It may not sound radical to us today, but it was really radical in its own time. He said, Massachusetts court, these writs of assistance, they're unconstitutional. They violate the British Constitution. They're illegal. They violate the English common law, and they run against natural rights, those rights that are given by God or nature just because we are born. So in the end, court, you need to step in and declare these writs of assistance void and say that they're unconstitutional. And in the end, it's because Otis is saying that these writs are violating some really important principles that have long been recognized in English law and long been recognized more broadly as the natural rights of men. One of them being that a man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. And in the end, what Otis is also arguing, though, is that these writs of assistance, they run against really deep rule of law values. As he said, it is a power that places the liberty of every man in the hands of every petty officer. And so it's giving broad discretion to petty British officials. And so the rule of law breaks down. Every decision is just turning on these private decisions of petty British officials. For the colonists, this was the very definition of despotism and tyranny. It violated the British Constitution, the English common law, and the natural rights of human beings. In the end, it's important to note, Otis loses. So these were all losing arguments before the Massachusetts court, but they would prove deeply influential for the founding generation. Part of the reason why is that who was sitting in the courtroom that day in Massachusetts but a young John Adams. John Adams, who revered James Otis, was sitting there with his little notepad, writing down everything that Otis said excitedly on his pad, excited by what Otis was saying. And in the end, what Adams would look back at this moment, and what he'd say is that that Otis's argument was, quote, the first scene of the first act of opposition to the arbitrary claims of Great Britain. Then and there, the child independence was born. For Adams, this is the very beginning of the American Revolution, at least in ideas, 15 years before the Declaration of Independence. The other reason we remember this is that American justices, Supreme Court justices, have not forgotten the story. And so often when talking about the original meaning, the history of the Fourth Amendment, they return to the story of James Otis as stating important principles that are meant to be protected by the Fourth Amendment. So we'll see this in a little bit when we talk about the Olmsted case in the 1920s and a famous dissent by Justice Louis Brandeis. But we saw this even just a few years ago at the Supreme Court. There was an important decision on the Fourth Amendment written by Chief Justice John Roberts about cell phones. And right there again, he referenced this James Otis story as a core, a core story that meant quite a bit to those who framed and ratified the Fourth Amendment.
Yeah, it's so great. Like we can see this revolution sparking, like Adam says, because all of those list of grievances that we see in the Declaration of Independence were those, crimes against the sort of natural rights, and and then holding on to that and putting it into and first the state constitutions, and then the Fourth Amendment in the Bill of Rights, but with James Madison here.
Yeah, absolutely. So, I mean, what we see is that they certainly knew James Otis's story. And when James Madison and his allies in Congress were writing the Fourth Amendment, they were really concerned about general warrants, because they thought that these warrants, they allowed royal agents in colonial times to conduct broad searches without limits and gave them arbitrary power. In part, the reason why they were so concerned about this is that how is the government often going to use this power? It's going to use it to crack down on dissenters. It's going to crack down on the rabble-rousers, on those who are criticizing the government. And so there's a concern about giving the government too much power in this context, in part because we care so much about the sanctity of our homes, of our property. And while we do understand there are genuine interests that the government has to enforce its laws, and so these searches and seizures are sometimes necessary, the Fourth Amendment, and the framers thought this, really had to put in place certain protections to force the government to provide good reasons before it could search or seize our persons, houses, papers, and effects. As Jenna said, part of the reason we know this was so important is because in the state constitutions that came before the Fourth Amendment and before the Constitution itself, many of those state constitutions had specific provisions in their bills of rights that attacked general warrants. Here's a famous one on the screen from the Virginia Declaration of Rights. And when James Madison was writing the Fourth Amendment itself, he had many of these state constitutions by his side and was drawing on many of the big ideas that we got from state constitutions.
All right, we are getting so many questions in the chat, so I do definitely want to save time for them at the end, because there's lots of, I think what people are realizing is that a lot of there's different scenarios are going to lead to different results. So I think some of these questions about, especially with the digital age. So I do want to get into some of those cases, and I love that the cases that we look at all involve telephones. But before we dive into the cases, can you give us a little bit of background on the framework that you need when you're looking for a Fourth Amendment case and deciding whether it's constitutional or not? What are some of the questions we need to ask? And students, keep these in mind and ask them as we talk about each one of these cases.
Yeah, so this is the general framework that we're extracting from a lot of Fourth Amendment cases before the Supreme Court. And so if you're looking at a Fourth Amendment problem, these are the questions that you're going to ask. The first big question is whether there's a search or seizure. If there's no search or seizure, there's no Fourth Amendment violation. So what's a search? Well, entering someone's home to look for evidence, that's a pretty clear search. But if you're just passively observing someone in plain view in the public, that's not a search. When the government restrains someone or takes their property, there's a seizure. When the government doesn't, there isn't. What we'll also see, though, in the cases we cover today is this question of whether there's a government search is often a really difficult one. And a lot of the court's cases are precisely about how we define that term. But again, if there's no search, no seizure, there's no Fourth Amendment violation. But if there is a search or seizure, we then have to ask the big question under the Fourth Amendment, which is whether that search or seizure is reasonable. So generally what we know is that the police need to go to a judge and secure a warrant supported by probable cause before searching a home or seizing property. So here again, probable cause is requiring a fair probability that, for instance, the relevant evidence of a crime will be found in the place or thing to be searched. And there are times when a warrant, though, is not required. The police may search you during an arrest we're at a checkpoint, or when there's imminent danger that someone might be hurt, a suspect might flee, or evidence might be destroyed, as in a drug raid. And so these are all really important exceptions to the warrant requirement. Finally, the last question is, what happens when there's a Fourth Amendment violation? And there it's generally courts are going to apply what's known as the exclusionary rule, throwing out evidence in criminal trials when the police got it by violating the Fourth Amendment. So this rule, it's controversial, but it's meant to check police abuses. But again, there are exceptions. For example, if police officers were acting in good faith and made a mistake. And Jenna, if you could wait just one moment, there's someone knocking on my door. So I just want to see who that is. I will be back.
Yeah, absolutely. So to recap what Tom just said, everyone, when we're looking at these cases, we are going to ask those big questions. Was there a search or seizure? If there's not a search or seizure, if that doesn't happen, then it's not a Fourth Amendment case. And so it does not apply. If there was a search or seizure, was it a reasonable search? And what makes something reasonable versus not reasonable? Well, there's a couple criteria that we can provide. Was there probable cause, or was there a warrant? So, the big exception is the warrant. You have to get a warrant. It says it right there in the Fourth Amendment. If there wasn't a warrant, did the searching party, the police, have probable cause? And then if there wasn't a warrant or probable cause, does the exclusionary rule come into play? Is that evidence that was collected going to be still permissible in court? And for what reasons? Was there for example, there was a good faith acting on the police's part. So those are the kind of questions that we're going to ask as we're looking at these. So the first case we're going to look at is going to be the Olmsted case. And I'm really excited about this one because it's the height of prohibition. We had this phone because all of these cases are going to be about phones, which is really an interesting through line kind of because it really does show how technology has changed. The telephone is a great example of even 100 years ago, telephones are different now. And so I think that's kind of going on this journey with phones is really cool. So Olmsted versus the United States, height of prohibition. Tom, tell us the facts of this case.
Absolutely. Yeah. So it's 1928. The government's trying to attack illegal alcohol. And the federal agents, they're investigating this man, Roy Olmsted, which we saw on the previous screen, for running an illegal liquor business. And so they suspect that he did this. And in order to figure out whether or not he did, without getting a warrant first, they decide to install wiretaps on the phone lines leading into his office, as well as into Olmsted's home. And just to give you a sense of what wiretapping meant, the government actually had to go underground, under the public streets, and physically attach a wire to tap the phone line. Similarly, had to go into the basement of the building that where Olmsted's office was, and similarly, sort of physically tap those phone lines. And so with that, they're able to listen to the suspect's phone conversations. And there, the agents actually uncovered evidence that Olmsted, he was selling illegal liquor. And so Olmsted, those steps in, and he argues that these wiretaps, they violate the Fourth Amendment. They're an unreasonable search and seizure. You, the government, you didn't go and get a warrant before doing this. But importantly, in a 5-4 decision, Olmsted loses. And so we see two really important and powerful opinions on either side of this case. On the one hand, we see an opinion by Chief Justice William Howard Taft. And so what Taft ends up arguing in his opinion is effectively that if there's no physical trespass, there's no constitutional violation. And so for Taft, the Fourth Amendment is all about physical things. It's about physically entering someone's home, physically rummaging through their desk, physically taking their stuff. And so if you don't have this physical trespass, there's no constitutional violation. The Fourth Amendment simply isn't violated in this case because they never went into Olmsted's home. They never went into Olmsted's office. Instead, they did these things under the public streets and also in the basement of the office building where he was leasing his office. In part, what Taft says is the founding generation really linked the Fourth Amendment protections to property rights. And so he argues the court should do the same. So in effect, really looking at the Fourth Amendment's text and history and limiting its reach to physical intrusions.
At the castle, the castle is what's protected. Those exactly. Walls of the castle.
Exactly. It's very simple. And you can imagine why 5 of the justices might have gone along with this decision. It's a very easy to apply rule. And there have long also been other justices who have wanted to go back more to the way Taft looks at these things. But on the flip side, we see a really important dissent by Justice Louis Brandeis. And again, this is another reminder to read all of the opinions in key Supreme Court cases, because this is another one of those cases where the dissent proved really, really influential. And what Brandeis does is he sets out a really important challenge for the Supreme Court when trying to apply the broad language and principles of the Fourth Amendment to a new context, in this case, new technology. And here's what Brandeis said. He said, progress of science and espionage is not likely to stop with wiretapping. Ways may someday be developed by which the government, without physically intruding into the home, may extract secret records and introduce them into court. And so Brandeis here, he's envisioning cloud computing roughly a century ahead of time. So what a visionary descent. But he's trying to look ahead. And what are not only are there new technologies now, but what are the new technologies going to be in the future? And what rules do we need in place with how we handle Fourth Amendment cases to make sure that we're applying the Fourth Amendment correctly? Then he says, at the time of the framing of far smaller intrusion, the general warrants that sparked the American Revolution, he's talking about our friend James Otis, were held to be unconscionable violations of liberty. Can it be that the Constitution does not afford protections against similar invasions in light of new technology? And so what Brandeis is saying here is that when interpreting important provisions of the Bill of Rights, one thing that we have to keep in mind is that we want to protect at least as much as the framing generation did. And so when we're thinking about how to translate old principles to new contexts, we want to provide, in the case of the Fourth Amendment, at least as many protections for people's persons, houses, papers, and effects today as the framing generation did with how they applied it in their own time.
Right, because this is information going in and out of the home in a manner that the framers never even considered or thought of. And so that's, kind of having to take that into account. Does this spirit of the Fourth Amendment still apply? Okay, so let's look at another case still involving a telephone, but this one not involving someone's home, and what their expectation of privacy was. And that's Katz versus the United States. And Katz was in this old-fashioned telephone booth where kind of the kind that Superman used to use to get changed in. So tell us about Katz and what his case was about.
Absolutely. So it's 40 years after Olmsted. We're in the 1960s. Charles Katz, the government here suspected that he was running an illegal gambling operation out of a phone booth. And so the government, what they do here is, they attach an eavesdropping device to the outside of a public phone booth used by Katz. They didn't get a warrant before doing this. This allows them to hear at least Katz's side of these conversations inside the public phone booth. And based on the recordings of his end of the conversation, they found, Katz actually was. He was carrying out an illegal gambling ring that spanned multiple states. And so that violated federal law. In the end, Katz steps in and he argues that, again, the government violated the Fourth Amendment by listening in on his conversation, by doing this eavesdropping without getting a warrant. And so the government, of course, responds saying, look, you're wrong, Katz. Read Olmsted. Under Olmsted, we win. There's no physical invasion into your personal property or private property here. And so we should win this case. But in the end, the Supreme Court sides with Katz. So Katz wins. And in the process, it overrules Olmsted, and it's a requirement of a physical trespass to have a search that triggers the Fourth Amendment. This is a really, really big deal. The Supreme Court's setting out a new approach to how it's going to decide whether or not there's been a government search that triggers Fourth Amendment protection. So the court rules that Katz was entitled to Fourth Amendment protection for his conversations, and that a physical intrusion into the area he occupied wasn't necessary to bring the amendment into play. So they're effectively saying, no, we side more with Justice Brandeis than we do with Justice Taft, the Chief Justice Taft in Olmsted. And so although public phone booth, it's in a public space rather than private property, individuals have a strong expectation that such conversations will not be overheard. A key thing that they focus on in the case itself is that when Katz gets into the phone booth, he closes the door behind him. And so he's closed into his own little private setting there. And this is seen as an important way in which it's increasing his expectation of privacy. What Justice Potter Stewart in his majority opinion famously says is that the Fourth Amendment protects people, not places. In many ways, though, the most important opinion in the case is a concurring opinion, a separate opinion written by Justice John Marshall Harlan, where he said that the Fourth Amendment protections apply whenever the individual has a quote unquote reasonable expectation of privacy. He sets out a two-part test to figure out whether or not there is a reasonable expectation of privacy. One, did the individual have a subjective expectation of privacy? So did the individual themselves expect, in this case, a conversation to remain private? And that's where closing the phone booth door behind you makes a difference for that inquiry. And then the second was an objective inquiry, which was that expectation of privacy one that society would recognize as reasonable? the court would then go on to apply this reasonable expectation of privacy test from Harlan's concurrence in Katz in future cases.
And we're getting a lot of questions in the chat about that kind of right to privacy and the Fourth Amendment and their relationship. We got it from Haley, Johan, Fred, all kind of bringing up this idea of the right to privacy. Is this the first time that we see the Supreme Court kind of connecting privacy and the Fourth Amendment?
So, I mean, there were certainly arguments about that. This is all in the same general time when the court also recognizes a broader right to privacy in the Constitution, in the case called Griswold versus Connecticut. Both of these cases happened in the 1960s. In part of the reason the court ends up saying that we have a right to privacy, even though it's not specifically written into the Constitution, is because there are key Bill of Rights protections that seem to be important indications of privacy rights, and the court specifically references the Fourth Amendment as a key example of that to reinforce a broader right to privacy recognized under the 14th Amendment of the Constitution.
Great. Thanks for clearing that up, Tom. Yeah, because we had a lot of questions about that. I do want to, before we go into the hypothetical, can you explain to us what third-party doctrine is? Because I know that comes into play. So sort of these last couple cases, these people, it was their own information, their own phone calls. But when we talk about like cell phone companies, or somebody was asking about like social media platforms, things like that, we're talking about third-party companies or organizations. So what does the third-party doctrine mean, and how does that apply to Fourth Amendment cases going into Carpenter?
Yeah, so again, let's put from Katz, we're pulling this reasonable expectation of privacy test. That's going to tell us whether there's been a government search and therefore the Fourth Amendment applies. The third-party doctrine cases were about carving out parts, basically carving out situations where the Fourth Amendment was not going to apply. Specifically, these are instances in which we share our information with a third party. And so this would be an example of our bank information. We share it with our bank. So the bank has bank records when we make phone calls. The phone companies end up keeping records of who we call. So what those phone numbers are, using what's known as a pen register. And the question was, does the Fourth Amendment apply to that sort of stuff when the government wants to get it as part of an investigation? And what the third-party doctrine says in cases called United States versus Miller in 1976 and Smith versus Maryland in 1979 is that when the government tries to obtain third-party information like bank records or pen registers, that is generally not a search for Fourth Amendment purposes. We're giving up that information to a third party, and so therefore the government generally doesn't have to get a warrant before going and getting that information. And so a key question as we get into the digital age is whether that third-party doctrine then applies to things like your location data from your cell phones. So the big question is, does the third-party doctrine apply, and therefore there's no Fourth Amendment protection, no Fourth Amendment violation, the government doesn't need to get a warrant? Or should we not apply the third-party doctrine to that particular circumstances? And as a result, the general rule should apply, and we see whether or not there's a reasonable expectation of privacy, and if there is, the government generally has to get a warrant.
Okay, so that's all of the facts kind of in the history leading up to our hypothetical question, which I mentioned was based on Carpenter v. United States, another telephone, in this case, a cell phone that looks a little bit more familiar to people like you and me, something that we would carry around in our pockets. This case from 2018. And the question is really, can the government track you 24 hours a day, 7 days a week for an entire month using your cell phone data and location information? Now, people were weighing in at the beginning based on what you learned today. What do you think? How would you decide this case if you were a justice? Think about that. Why, Tom, you tell us the facts of the case.
Yeah, absolutely. So someone asked at the beginning, who is Carpenter? Well, Carpenter is Timothy Carpenter.
Sorry.
And so the Carpenter decision here, it involves police officers investigating a string of armed robberies. So the police officers, they arrest 4 men in these armed robberies. One of the men confesses. He gives the FBI his cell phone, and the agents get the cell phone numbers of many of his accomplices, and then use this information in the suspect's call log to get the cell phone records of the other suspects, including geolocation data about where these suspects were at various points in time. A key fact here is, although the government didn't get a warrant before going to get that cell phone data, instead they requested this data through a national law, the Stored Communications Act, which was a law passed by Congress. And so by using this law, the government only had to say that the cell phone records were relevant to a legitimate criminal investigation. And this relevant standard, it's lower than the test for getting a warrant, which again is probable cause. So the police eventually arrest Timothy Carpenter based on the information they have. He's actually convicted. He's sentenced to 116 years in prison. So it's a really long prison sentence. And the question that Carpenter asks is the same one we're asking, which is, can the government do that? Can the FBI gain access to our cell phone records without a warrant? And so we've already, posed that hypothetical to you at the beginning of class. In the end, the Supreme Court, it's a tough question. They divide 5-4 in this case. But in the end, in an opinion written by Chief Justice John Roberts, the Supreme Court rules that the practices of acquiring a cell phone location information from cell phone companies is a Fourth Amendment search. So if the government wants that information, generally speaking, they have to go and get a warrant. What Roberts says in particular is he applies Katz and said that a person has a legitimate expectation of privacy in the record of his physical movements. And Roberts himself, he acknowledges, yes, we have this third-party doctrine. We've applied it to bank records. We've applied it to phone records in other contexts, the phone numbers we get from pen registers. I know that what I have to do in this case is figure out, do we extend that third-party doctrine to this new context where we're dealing with geolocational data from cell phones? And what Roberts and the majority says is, we are not going to extend the reach of the third-party doctrine. Why? Well, in part, it's because of just how pervasive the privacy violations are, or the privacy concerns are, when dealing with this cell phone information. And so what Roberts says is that it provides a sweeping mode of surveillance that gives the government the power of near perfect surveillance, as if it had attached an ankle monitor to the user's phone. This surveillance is quote unquote detailed, encyclopedic, and effortlessly compiled. It provides an all-encompassing record of the holder's whereabouts. Therefore, we're not going to extend the third-party doctrine. We're going to recognize in this context that someone like Carpenter had a reasonable expectation of privacy in this cell phone information. And generally speaking, we're going to require the government to go get a warrant, which it did not do in this context. Finally, as I said, it's a 5-4 decision. So we see a multiple dissent. Every one of the dissenters actually writes a dissent in this case. Justice Kennedy basically says, I think we should apply the third-party doctrine here. Bank records, they involve really private information. Who you're calling on your phones, that can require that we get from the pen register. That's really private information. I see this cell phone data as very similar to the information we've applied the third-party doctrine to in the past. And so I think the same rule should apply here. Justice Thomas steps in and he says, look, I think the right question to ask in a case like this is, whose property is at issue? And if you look under the law, in this case, the property in the cell phone records under the law doesn't belong to Timothy Carpenter. Technically, it applies to the cell phone company. So there's no Fourth Amendment protection to it. Justice Alito steps in and basically he just criticizes the majority from departing from well-established precedent. And then finally, we see a really interesting dissent by Justice Neil Gorsuch, where he really probes the limits of each of the proposed approaches, offers some tentative thoughts of his own, but importantly says, look, I haven't totally made up my mind. This is a really hard question. We're just beginning to wrestle with it. I need to do some more thinking. Here are some thoughts. Maybe over time, we'll be able to come up with an approach that'll work for all of us.
Yeah, so I think the fact that there's 4 different dissenters with 4 different dissents shows just how complicated these questions can be and how nuanced they can be. But like you said, in the majority decided that this kind of the search, the information was so broad and all encompassing that it did kind of cross that line into a Fourth Amendment violation. And at the end of the day, the big idea we know, before the government can search your home or seize your property, it needs a good reason. That's our big idea for the class.
Exactly.
All right. So students, that concludes the formal portion of our class today. Thank you for joining us. I'm going to keep Tom for a couple minutes because we have some great questions in the chat that you can certainly stick around and talk to us about. But I definitely wanted to get to some of these because they're really interesting. And again, those sort of those circumstances and nuances. So let me pause. All right. Okay, so questions that I think the students mind about schools and, locker searches, things like that. And then does that change when you're going from a high school when you're dealing with minors and maybe even a public school versus a college dorm room? And what are the what's the law there? What's the case law say in those instances?
Yeah, so that's great. I mean, so basically what the Supreme Court said, and the key case here is a case known as TLO. And so what the court says, they say a few different things. And frankly, it's similar to how the Supreme Court applies the First Amendment inside schools too, which is to say on the one hand, yes, the Fourth Amendment applies here. So it's not a Fourth Amendment free zone. There are important Fourth Amendment interests involved, say when you're searching a student's locker, or in the case of TLO, it was a student's purse searching for illegal drugs. But what the court said is that some different rules are going to apply inside the schools that apply outside the schools. So generally speaking, we're not going to require a warrant requirement or probable cause. Instead, the right standard there is going to be reasonable suspicion that a law has been violated or a school rule has been violated. And again, in the case of TLO, the school officials are searching the purse of the student. And in the end, it was decided they did have a reasonable suspicion that the student had violated a rule. And as a result, the student loses, the school wins. But it is to say that there are limits to what government officials can do in this context. Another example is a case known as Safford Union School District versus Reading, which involved a strip search of a middle school student. And there they were searching for, there were allegations that the student had been distributing illegal pain medication to other of her classmates. And so there was an investigation, and then they actually conducted a strip search of the student. And the court applied the same rules that they found in TLO, but said that no, in this circumstance, the school has gone too far. One, they didn't really meet the requisite reasonable level of suspicion. But the other thing that you get from the court there is there's also a sense of proportionality. And the idea that there's something unreasonable about a search, if we're dealing with pain, violation of maybe a student handing out pain medicine, the government just doesn't have plenary authority to do whatever it wants, including a strip search of a middle school student. And so you could see there both the degree to which the Fourth Amendment operates differently inside the schools, but also seeing that there are limits in place to what school officials can do in that context. And you would think that the age of the student being a middle schooler, I think also had something to do with how the court analyzed that case. And I think that the age, whether it's a middle schooler, high schooler, or in a university setting, would probably inform what ends up being reasonable in the context of a search that's being done. I don't recall, and I may just not remember it, the Supreme Court deciding squarely a case addressing a search at a public university. And so I don't know exactly, how much it would differ, but at least those are two things with TLO and the Reading case, like two poles of how the court more broadly has applied the Fourth Amendment inside our schools.
Thank you, Tom. Yeah, that's really helpful, and I think definitely relevant to students who are learning about this, knowing what their own rights are within the school. Like I said, a lot of questions about a couple that I think, based on what you've taught me about the Fourth Amendment, would not constitute a search. And so I just want to confirm that I'm on the right path. One about social media and kind of people who share where they are, what they're doing, pictures of themselves all over social media. If the police or the government use that to kind of track you and your movements, I would not consider that an illegal search because you've volunteered that information yourself. Would that be accurate?
Yeah, I mean, the Supreme Court's never decided a case like that, but I would guess that they would analogize it to if I were, sitting on the streets and observing someone out in public. It's not exactly like that, but I think that they would see that as analogous, and as a result, it wouldn't be a search.
And that was kind of the similar question about, using like satellite cameras to track someone versus their personal device. If they're out and about and they're using a government satellite, for instance, to track you, again, that to me does not seem like it would constitute a search.
Yes, I think that's right. I think it would require the court to change its views somewhat of the Fourth Amendment to sweep in that sort of government surveillance into greater limits.
And then a couple questions coming in about like AI. Curious about how government can use AI technologies without violating the Fourth Amendment. I'm not sure. Maybe we can clarify exactly what you mean by that, Percy. And then if you gave out, sorry, these are all coming in really fast. Sorry, Tom.
Mm-hmm.
So companies.
Yeah, I mean, I think as to the AI question, I mean, more broadly, insofar as AI is using publicly available information on the internet as it often is right now, I would imagine there wouldn't be a big problem. But you could imagine circumstances in which it's using more government proprietary information that may implicate Fourth Amendment concerns. So I think it would go a little bit between whether the government's relying on, some of its own information to target people versus publicly available information. But I'm just riffing here. These questions are so new. And also the sweep of AI is unknown, that it's hard to precisely predict, one, what AI is going to be able to do, and two, precisely how the court's going to look at things like that.
I think there's another question about tech companies like Google, Apple. I don't know whether those would apply under third-party doctrine, or if Carpenter would come into place and say that we have so much information to Google and Apple that it's, I think these are all really great questions, and kind of going back to the Fourth Amendment framework that we talked about.
Yeah, I mean, the court hasn't decided anything since Carpenter, but you would imagine a lot of the broad principles you get from Carpenter, applying when we're dealing with, a lot of the other information that we're giving to cell phone companies as well, and would apply sort of similar reasoning. The only question being whether changes in the composition of the court, because it's a 5-4 decision, how that might reshape how the court looks at things. That's sort of a known unknown.
Especially as these tech companies are becoming more all-encompassing, like, it used to be a bank, a cell phone company, a cable provider. Now, like your email, your cell phone, your bank, Apple credit cards, like all are kind of one big company. I can imagine that like Carpenter would even apply more so in that case. But
yeah, no, and the other thing to note is that Carpenter is a bit of an outlier in that it's an ideologically divided, or it's a 5-4 opinion. It's a closely divided one. The Fourth Amendment is an area of the law that in the last 10 years, we've seen relatively more consensus between justices across the ideological spectrum. And so just a few years before Carpenter, there was a case called Riley versus California, which dealt with whether when you're being arrested, whether or not the warrant exception on arrest applies to the search of a cell phone. And so usually when you're arrested, one of the exceptions is that the police, they don't need to get a warrant to sort of pat you down and search you. The question is, does that warrant exception apply to the police then also looking inside of your cell phone, or should they need to get a warrant before doing that? And in a unanimous decision, the Supreme Court said, no, the police officers, the general rules applying, you should get a warrant before doing that. And so, again, in applying these, the Fourth Amendment to these new technological settings, it's not always, or even necessarily, or often an area where we see divisions on the court between ideology.
And then one more question I think I'll take, just kind of about legislation and the Patriot Act and how that has affected kind of Fourth Amendment, application over the past 20 years.
Yeah, it's a good question. The justices themselves vary on how much deference we should give to Congress and even state legislatures on these questions. And so in Carpenter, one of the things that Justice Kennedy says is that's another case, that's not a Patriot Act case, but that case, what the government's applying in that case is they're not just making stuff up, they're using a law passed by Congress to get access to this information. It's just rules apply that aren't quite as rigorous as the rules before getting a warrant. But in part, what Justice Kennedy says is, the Fourth Amendment talks about the reasonableness of searches. What we know about the Fourth Amendment is it's really, really hard to balance liberty interests against the need for national security and order over time. It's a fast-moving area of the law. We think legislatures, generally speaking, are good at balancing those interests and more likely to adapt to changes over time than we, the Supreme Court, are going to be. And so in really close questions, like a case like Carpenter, we're going to defer to what Congress said. So if Congress still requires some level of connection between a legitimate investigation and something before getting information, with something less than a warrant, and says that that's really important to be able to serve the interests of law and order, I'm okay with that. And sort of similarly, Justice Alito in the Riley case I just talked about, dealing with the search of a cell phone after someone's arrested, Alito went along with the majority and said, yeah, I think generally speaking, there should be a warrant here. But what he said is, again, this is an area where a lot is changing. And so if state legislatures over time come up with different approaches to how much protection to give people in those contexts by passing legislation, I'm not going to necessarily listen to everything they say, but I'm going to take a look at their arguments and what they've decided over time. That might shape how I apply the Fourth Amendment. And so it's to say that there is sort of like in the Fourth Amendment context, at least certain justices are open to some dialogue between what Congress and state legislatures are doing, the balances they strike and what they take to be reasonable in certain contexts versus, when the court needs to step in and enforce the Fourth Amendment. And there are, again, among the justices, various approaches as to how, how assertive they'll be in enforcing the Fourth Amendment right, even if the elected branches have stepped in versus not. And so it's a great question.
Yeah, great. Well, thank you, everybody. Thank you, Tom, for sticking around and asking those questions. We really hope you enjoyed learning with us today. Thanks for joining us, and have a great day.
Yeah, thank you, everyone. Great questions.
Come back on Friday for Clark Neely, and then we'll send out the end of week wrap up later in the week. All right. Thanks, everybody.
Bye, Jenna.
Bye. All right. Thank you. All right. Bye, everybody.